Hey all, David Matafari here. Just wanted to give another update on the case for St. George. The oral arguments in front of the First Circuit Court of Appeals was today. It was 45 minutes. There was no judgment rendered today. We probably won't get that till sometime late May or something like that. But very interesting. What we'll do here is I have a bunch of notes that I wrote, so you're going to see me looking down a lot at my sheet of paper because I want to just get everything that I caught from it and the issues that were being argued. With the case being an appeal, it means that they're appealing the ruling from the lower court. So the lower court essentially ruled in I guess it was like 4-page document that the incorporation of St. George was considered unreasonable. No one was arguing that the election was fraudulent or anything like that, but that based on the testimony of the economists from the mayor's side, economists from the St. George side, they have vastly different opinions on what was actually going to be, the budget for the city, the adverse reactions, effects to the city. The judge just declared that the incorporation of St. George was unreasonable, which, if left alone, would mean that the election would be null and void, and it's like it never happened. So there were 3 issues that the St. George proponents brought that they wanted to discuss during their time in front of the judges. The first one was standing, the issue of standing for Mayor Weston Broome and Lamont Cole. There were several dialogues from both sides surrounding this, about whether they could even bring this suit up in the first place. First, neither of them reside in the area of St. George. So by that account, they have no standing to bring a suit as a private citizen. Then the question becomes, can they bring the suit as an elected official or with official capacity or the authority? And, the question is whether the mayor can unilaterally bring this suit without given authority by the Metro Council. And so the quibbling was about whether the mayor already has that authority to do that or whether the Metro Council must give her the authority to do that. Councilman Lamont Cole is already a member of the council, so the mayor's side is saying that gives them the authority to bring it as their official capacity. St. George rebuttal being that he's one member of a councilman, as a councilman, not discussed in any of the proceedings, but just knowing that Councilman Dwight Hudson was named in the citizen appellant brief, meaning he clearly wouldn't have approved of his ability to bring this suit in place of the Metro Council. The statute's wording is actually very vague. It's vague enough that it had been worded more explicitly, and this was one exchange with the judge, had it been worded more explicitly as to what constitutes official authority or elected official capacity and how they get that authority in the case of bringing a case specific to challenging something like an incorporation. This case probably wouldn't have even stood in the lower court just on standing alone. That's a lot. To sum that up, St. George says that the mayor and Lamont Cole don't even have the standing to bring this case in the first place, and we shouldn't even be here. The second issue that was brought up was Baton Rouge's claim that this would have an adverse effect on the city and the city parish. St. George argued that the information, the numbers, and the studies showing that Baton Rouge would be adversely affected were made on erroneous inflated numbers. One of the examples they gave was the city of Baton Rouge was actually using city parish budget as opposed to just the city budget. And by doing that, they almost kind of set themselves up for this for St. George, because they were erroneously showing the loss of revenue to the city parish budget and showing that loss. But they were not showing also the flip side, which is all the liabilities and costs that they are not going to have to worry about anymore once St. George takes it over. And ignoring that and moving on, they started talking about that Baton Rouge's, the economists that they brought to the lower court all argued that St. George would run a deficit in day one, citing what they said, among other things, was an underfunded police budget and several of these unfunded accrued liabilities that would show that St. George would be running a deficit on day one. St. George came back with what I thought was probably, and they talk about this at the very end, the best rebuttal to this was that the underfunded liabilities were testified to be $5.1 million, not the $9 million that all of their economists had used to show that their budget would be inflated beyond the tax revenue St. George would be collecting. So right there's a $4 million discrepancy, and that $5.1 million was testified to by, I forgot the lady's name, but she works in the unfunded accrued liability department and said it on record under oath what those numbers would be. The second item that's regarding police funding was St. George included a $4 million discretionary budget item for policing. Baton Rouge had jumped on that and said cities of this size could not possibly run policing at $4 million. St. George comes back and states, we're already going to be receiving policing at the same level that we're getting now through the sheriff. This was a discretionary item should we decide to do that. If we're talking about just basic numbers year one, which is what a lot of this was being projected on, then you have $3.9 million that is from the unfunded accrued liabilities that's actually not there, that Baton Rouge claimed there would be. And then this $4 million discretionary budget item. If you take those two items away, St. George is running a positive cash flow from day one, not $4 million in the hole. Anything else that was discussed when it came to the economics was clearly, it was projections. And I liked when the judge even alluded to the fact that it is possible to make numbers project anything we want to satisfy our goals. So although St. George had one economist work on our budget and Baton Rouge brought in 3 or 4 economists that all said the same thing, clearly they're looking at different numbers and they can prove the point for either side. He left an open-ended question about should we be denying the will of the people based on economist projections when it comes to something like elections. At that moment, I kind of smiled, and then they moved on. The third item was the reasonable. What is this overt question of, is the incorporation reasonable? Which is naturally very vague, and it was actually a deciding factor in the lower court. He decided the ruling of the incorporation was unreasonable due to some of these, what I call glaring budget interpretations by Baton Rouge, projecting what they think St. George would be running at a deficit versus St. George saying we're going to run on a positive cash flow. This is where it kind of got into the weeds a bit, so I can't talk too much about it. The judge and the attorneys on both sides were throwing out statute numbers, 33.4A and 33.5B. We don't have those in front of us. I guess I can go dig them up. But the point being, it got a little obtuse, but they knew what they were talking about. And what it sounded to me was, at the end of the day, that the crux of the St. George argument is that when it comes to reasonableness, that the will of the people in an election should carry a lot more weight over one judge's determination that projected numbers are grounds to rule an election null for being unreasonable, especially when the people have been informed, for at least 2 or 3 years prior to going to this vote. That one, since that was the ruling that it was unreasonable, this one got a lot more technical than the other two that we discussed. All right, there was a fourth item, is a citizen appellants. There was a separate citizen brief that I actually signed. I was a part of the 238, citizens that signed on to the brief. It was just a matter to affirm constitutional right to an election, and that any opposition to a free, fair, and legally held vote could be viewed as election interference. One great comments from Drew Morrell is that it is election interference or election, voter suppression. It's just that Mayor Broom was very kind enough to let us have the election first and then tried to suppress the results of it. The statutes do state that an unreasonable ruling in the lower court had nothing to do with the constitutional rights of the citizens. It was not a point that was actually argued in the lower court. The constitutionality of the election should supersede everything. And therefore, because of that, any citizen that wanted to appeal the case could only argue the reasonableness ruling and not come to the appeals court and add in a constitutional aspect to this case at this stage. As a person that's never done this before or witnessing this, I get where he's coming from. Kind of makes sense if you're trying to narrow it down to the issues. The St. George counter argument is that it is only at the appeal stage that citizens have the opportunity to get their voice heard in these appellant briefs, because and when the judge asked why it wasn't part of the original trial in the lower court, why the constitutionality aspect was not part of that lower trial, is because that the lower court was only dealing with the named defendants in the case, and those were the two petitioners, Chris Riles and Norman Browning. And that no one was actually arguing that an election had been held. It was only after the ruling of unreasonableness effectively nullified the will of the people's vote that the issue of constitutionality arose around that particular statute. And I thought that was a very strong point to make, because if we're talking about a constitutional state, constitutional republic, these are very grave things that we hold near and dear: free and fair elections and the will of the people for self-determination. With all that, the court adjourned. It was the St. George got the rebuttal at the end, and that was it. There will be no ruling for possibly 2 months. What we do know is that, as I said at the beginning, it's going to be appealed to the state Supreme Court. I'm going to do a separate video describing the scenarios that could play out as they were explained to me by Drew Morrell and some of the attorneys I work with the transition district. That was a lot of words. I am thirsty. I'm going to get a glass of water, and I will see you guys on the next video regarding St. George.